Institutions Committee. Got it right. And today is Wednesday, February 5th. It's 1 p.m. And we are talking about victims notification. And our first witness is Tim Leader Dumont, the Executive Director of Vermont Department of State's Attorneys and Sheriffs. And please feel free to take over.
Thank you very much. Tim Leaders, Dumont, Department of State's Attorneys and Sheriffs. With me here today, we have two victim advocates and one state's attorney. And the state's attorneys, they just pop up out of nowhere, so you got to watch out. But we have Megan Place from Windsor County. If Megan wants to say hi for a second, she brought chocolates from Windsor County as well. And also Shay Kennedy from Rutland County, and our state's attorney from Rutland County as well, who's one of my 28 bosses and sits on our executive committee of state's attorneys, who's here for other purposes, but just figured he'd come in and be available to you all. And I really wanted to make this as informal as possible. We have two victim advocates here who work on our front lines. So if you have any questions, I'll just have them answer a lot of the questions, particularly the tough ones about how things are going with respect to the current earned time credit and our communications with victims, as well as things like victim handoff, right? When there's the investigation with police, then there's the filed case, the victim advocates are with us, then after a conviction, if a conviction occurs, over to the Department of Corrections. And they can talk to you about that whole experience. Megan has spent time working for our department and with the Department of Corrections, so she has lots of experience. Back in the fall, we conducted a survey in response to Act 159 of 2024. And that survey has been posted on your website. Just briefly, contextually, our victim advocates, we have 27 victim advocates in our department, spread across the 14 counties. They have about 600 cases assigned to each of them on average as a sort of a snapshot. That's really, really an inappropriately high number in terms of the type of time that you really need with each case. That doesn't include the number of victims attached to each case. So there's a homicide, could be a whole family of 20, 30 people that you're communicating. So dealing with many thousands of victims. We have 23,000 pending cases in our court system right now that we are staffing, and our 27 victim advocates are working on those 23,000 cases. They do everything from notification of hearings, communication of victim impact statements, handoff with police on the day of arraignment, leading up to arraignment. And they're really embedded locally, and many of them serve for longer terms than our state's attorneys, deputy state's attorneys, and so they have institutional knowledge as well, which is just key to the department. And they are proudly represented by the VSCA as an organized group, victim advocates. So earned time credit, and why we're sort of here today, some of the questions were, if we expanded it, the state of Vermont expanded it to educational credits within our facilities, what would our opinion be about that, right? There's the current earned time credit, and what would our opinion be if it were to expand? And then relatedly, for parolees, if it expanded for parolees, relatedly, if it expanded and relatedly, how's the notification system going with our current sentence population? We administered a survey of the 27 victim advocates, 15 responded, which is pretty good. 55% of the folks responded. And I would say many of our senior folks responded. We did make sure that it was confidential so they could be very blunt and forthright. I will say, because they won't mind me saying it, two of the folks that responded are in the room today. So I've identified two of them and done bad things to confidentiality. So the first question, should earned time be expanded to include parolees? 14 people said no, one didn't respond. They'll contextualize, and we'll start with Megan. My little notes on the screen here, TLD and MP. That means I'm going to hand the microphone to Megan in a second. She'll explain why that it isn't that we have some disdain for expansion of programming. It's because of our current experiences. The second piece, should earned time be expanded to allow for incarcerated individuals to earn time off their sentence for educational credits they work towards. So again, everyone that responded said no or didn't answer. Again, that is about our experiences. So I'll hand it to Megan to just briefly outline some of the why behind some of that from her perspective.
Sure, thanks, Tim. I think that generally speaking, advocates are adverse to the idea of the expansion just because of how difficult it's been to roll out this news to victims. we did, when we first passed legislation, I know we like did sort of a retroactive, there was like a pause, but we did it retroactively. When I was working for DOC, notifying victims that people were getting out much sooner than they thought was devastating to them. I can't really quantify how upsetting it was. You know, proactively, the state's attorney advocates do explain to victims, and it's really complicated to have that conversation. When you're like, yeah, we're going at like 5 years or 1 to 5, but you know, that they'll get like 7 days for every 30 days, but only if they're, you know, don't have any major disciplinary issues. What that means is like, I don't know, maybe you should talk to a DOC. It just really erodes any ability to have like a definitive conversation with a victim. And it makes it difficult for them to weigh in about sentencing. Because I think why they might be fine with like a 1 to 5 or whatever we're talking about, then they have to factor in all of these other things. I think when it comes to the expansion for educational credits, like, of course, we want to encourage people to be doing something with themselves when they're in the facility. We'd love if they could do it soon. A lot of victims feel that way. The problem that I have heard just anecdotally is like, I think back to like a sexual assault where a lot of those cases happen in a college age. A lot of mostly young women are not able to continue to pursue their own education because of the trauma they endure. So I just can't imagine having this conversation of like the person who perpetrated this harm on you is gonna get some time off their sentence for engaging in advanced education. I'm sorry that you are so traumatized you can't continue yours. And now you have $36,000 in debt that you owe and you don't have a degree because of this incident.
Can you do me a favor, Megan? Can you introduce yourself for the record?
Oh, I'm so sorry. Yes, I'm Megan Place. I'm a victims advocate for the Windsor County State's Attorney's Office, and I formerly worked as a victim services specialist.
Thank you.
So any questions, just while we've got Megan and Shay on this first piece about parolees and the educational credits?
Just the numbers, like, so there's 14. Is that all you asked was 14 people?
We asked
15 responses.
Oh, out of who'd you ask?
27 victim advocates.
Okay, gotcha.
So,
Oh, like you.
Mhm.
yeah,
Okay, so we're,
yeah,
that's all I need to know. Thank you.
very good question. Yep. Any other questions on this first piece? This is not a long presentation, by the way.
We have questions, but not on this piece yet.
Okay. The second piece is really, and some of this DOC will talk about the mechanics of, and we defer entirely to them. And, you know, the conversations and the handoff that happens with DOC and our victim advocates is an important piece. It requires resources, and it requires adequate resources for both our department and for DOC to effectively do that work. So I'll put that out there that victims deserve to have communication regardless of where they're at in the quote intercept, wherever they're at in the criminal justice system. But in terms of the confidence that our victim advocates had in operation and effectiveness, and I was corrected this morning, it's called VINE, not VANS.
Yes.
So ignore that it says VANS, it is called VINE. But in that system, right, it's, and this is no attribution of fault to DOC employees, it's more it's a system of government, right? Not a high level of confidence in the operation of the VANS system, right? So 12 said no real confidence, right? 2 said yes, 1 didn't answer. In terms of the VINE system ability to effectively handle an expansion. So if we're compounding something, we're making, from our perspective, something that's not currently working super well for victims, expanding the scope of that, everyone that answered said no confidence in that. Yeah.
So it's probably both, but is it an issue of technology or that can't keep up with the new request, basically? Or is it a human part that you don't have enough staffing to do that as well, or a combination thereof?
Good questions, and I'll bifurcate one to say on how it works. I'll defer to DOC. Shay Kennedy from Rutland County, our victim advocate, has spent a lot of time thinking through some of these policy issues, and I'll hand it over to her if that's okay. If you could identify yourself, talk through some of that question.
Hi, I'm Shay Kennedy. I'm one of the victim advocates in Rutland County. I started with our office back in 2017, so I've been working with this program for some time. I was also with the department when they did the first rollout of earned or good time and how that information that was given to victims. I think there's this assumption that every victim of crime is automatically enrolled in this program, and that is inaccurate. it actually relies on either a victim to register themselves, a victim advocate to register them, or DOC Victim Services to register a victim. So it's not this automated thing that victims are automatically enrolled in. And before I'm putting someone's contact information for a program to automatically contact them, I want to make sure that we have permission to do that. Do you want your information in this system? How do you want to receive notifications? Is it phone calls? Is it text messages? Is it emails? And walking through with a victim what these notifications entail, what they will say when they are sent out to people. That's also an educational piece that has to be done with every single victim. So on the front end of things, it is the victim advocates having these conversations with every single victim. A great benefit of Vine that we have is that it will automatically tell someone whenever an offender is booked in or out of the facility. For people that are held on bail or could potentially be reaching the end of their sentence, that's great for a victim who's been perpetrated by somebody who's actually in the facility. If somebody is already on a community sentence such as furlough, they may not want to be enrolled in Vine because what does it matter to them? This person is already out in the community. There's not going to be that switch or immediate safety planning that they might have concern for. So putting people in this program when they are on parole, furlough, or even a probationary sentence, it's just not always appropriate, and people don't always want to be included in this. Why is this? If you receive a phone call, it's a number from Kentucky. With the amount of spam calls people get these days, they don't answer their phone when they get that. So that's another upfront thing that victim advocates do. Like, you're going to get a phone number from Kentucky. You have to enter a PIN number or else they're going to keep calling you. You have to remember what your PIN number is. And if you don't, these are the people you can contact or how you change that. So there's a lot of this that goes in. And this is just a way for victims to get notice of what Vine is going to send them. I think, I know working with DOC Victim Services, we're actively trying to improve the messaging that goes out in those notifications as well, but they are so broad to try to compensate for all the information, especially on earn time, that they're often inaccurate. If an offender is being held without bail pre-trial and is not eligible to be earned time because they're not even sentenced, victims are still receiving a notification that says this offender can earn up to 7 days off their minimum and maximum sentence. That freaks a victim out every single time. And it's on the system, the way it works, it's not always ideal when they get this message. Is it going to be 5 o'clock on a Friday when you get this message? And then who do you call? State's Attorney's Office, we're not there. DOC Victim Services obviously can't be available 24/7. And so there leaves a giant question mark that causes a lot of anxiety for victims.
Thank you. And so DOC, we're going to ask you when it's your turn. So just keep that in your head. Kevin? Kevin?
Is this the time to ask, why is it so complex to notify the victim? I understand if they're not in the system, but if they're in the system, why is it so complex to notify them?
Oh, what? I'm sorry.
That there's a potential change that could affect them. Why can't, to show my ignorance, why can't they get a text that says, we have information you may be interested in, period. Call this number.
Certainly, and
Some of that may be better for DOC to, on my sentence side. On our side, in terms of, let's say, prior to a sentence being imposed, a really busy example is on arraignment day or on a pretrial day where we got 40, 50 cases. So our victim advocates are, I mean, it's literally see them chugging Gatorade in the hallway because it is constant. You are constantly on the phone communicating to victims. We made an offer in this case. We did this and that. So this doesn't have to do with the post-sentence piece, but it is a really complex human interaction experience when we're saying, hey, we just offered them an arraignment only deal to have time served over the weekend and then they're out, right? So in terms of then doing a handoff on that same day over here for a sentence population, it can get complex pretty quickly. But I will say that I think we're working on improving some of those handoff pieces. But I don't, DOC can talk to how for a sentenced person that communication does or doesn't happen depending on if they have the information.
Thank you.
In terms of some qualitative, that was quantitative, the numbers that we had gathered. In terms of some qualitative feedback, in terms of the overall question, like when a bill gets generated over here and it's about reducing the time that someone's going to serve, people get angsty in the victim population because it's about moving the goalposts from their perspective. So the message that, and I say this type of approach, this is a direct quote from one of the victim advocates, would send the victims that their experience doesn't matter, right? So you've been through the system, and also different, if this law changed, let's say it wasn't retroactive, victims in the future will have a different experience than victims in the past. And that creates another level of inequity in terms of persons who experience different outcomes going through the criminal justice system as victims. The second point, Shay, if you want to speak to the second point here, that'd be great in terms of your experience. It's the never-ending frustration trip. Yeah.
Yes, I think Tim talking about moving the goalposts, that's often what's happening. If a victim advocate is sitting with a victim at the time of sentencing, and they sit and hear from the judge themselves, this is what the plea agreement says, or post-trial, post-conviction, this is what the sentence is, whatever that may be, 1 to 5, right? We can tell a person, yes, it is 1 to 5 on paper, but moving forward, they have this ability, I call it DOC math, right? DOC will do their math and it will change what the potential sentence is. There's no truth in the sentencing. There's no finality of when they think it might be over. And if they have an expectation, right, that this person is going to be on supervision for a maximum of 5 years, and that's what they hear from the judge, if that 5 years is continually chipped away at, what was the point in them coming at a sentencing? What was the point in them putting their heart out to the court and writing an impact statement to tell them, this is how awful this was. Maybe I do or I don't agree with the sentence. I think they should have more. But then they finally get a sentence, and even that's not true. It will continually change. And that is always stressful, super frustrating. And it often leads people why'd I call the police? Why'd I do this in the first place? And if they're victimized again in the future, I think that compromises, how people will continue to engage in the criminal justice system.
And then Megan, if you want to speak to the next.
Yeah, I don't really think I have anything to add. I think that the legislature, that impacting and eroding the confidence in the criminal legal system is a widespread issue among the victim population. It's just what Shay was saying. People who really put themselves in dangerous, vulnerable situations. The people we're incarcerating are not typically people that are committing retail thefts. These are sexual assaults, domestic violence, aggravated assaults, homicides. These are very, very traumatized individuals who often have to participate all the way up and through a trial process. So they have already been through the ringer. These are cases that have lasted, unfortunately, 3, 4, 5, 6 years. If they're convicted at trial, we're talking about PCRs, appeals, and then
PCR is a post-conviction relief
Yes, sorry.
matter. Yes.
there are all kinds of ways that victims sort of get the carpet pulled out from under them. And unfortunately, earned time is just another one of those ways. And when I was briefly with DOC just for a couple of years, one of the most devastating calls I made was to somebody who the crime had happened in the 80s. And it was a very long sentence, but they were getting out about 15 years earlier than they thought. And I was able to finally reach this family, and the children were grown. And she was just beside herself. They had to get everybody back into therapy, and there was earned time credits applied. I had to consult with the experts at DOC about how credit was applied. But because of the various ways we've changed this legislatively over the years, it ended up adding up to a 15-year difference. And this is a person that they were hoping was never going to be in the community again. So you can imagine. I'm sure.
Yeah. So, and you guys have the committee has the underlying survey on your website in a 9-page format. This is just a visual aid for you all, but you've heard finality is a big deal for our victims and our victim advocates. Having, the automation is helpful for some folks, but then also that human approach as well. And that does require resources, making sure that there's enough people to reach out to victims for incarcerated, that are related to incarcerated persons. The other piece I wanted to just mention is that, and I think we're working through some of this, making sure the notices are written so that regular folks in Vermont can understand what they mean. And they're reduced to what some legislative counsel here call plain speak. But it is important that our laws and our interactions with the justice system are reduced to language that folks can understand in their daily life. And also, I think part of what you're hearing today that we're doing in general, and part of the reason we pulled a couple of people out from the counties, is to educate legislators and the general public about the differences between state's attorney victim advocates as opposed to community advocates that may work in a network organization, DOC advocates, There's some differences in what different types of advocates can do, and we're the ones holding the ball through that backlog process too. State's Attorney Sullivan and I are working on a lot of data extraction these days. We're dealing with a court backlog. So by the time these cases, which are the most serious cases, because people are not getting sentenced for low-level crimes in Vermont to incarcerative terms, these are serious cases. By the time a case goes through the backlog and a sentence occurs, for further alterations to occur, they've already had to deal with the backlog in the state of Vermont, which is a collective failure of all the prongs of the stool of the justice system. So hopefully this has been helpful. I think some of the takeaways, we like to be very blunt and direct in our department. The takeaways are the victim advocates are not supportive of expansion of earned time credit. And doesn't mean we're not supportive of educational opportunities in the facilities. Very supportive of that. That's essential to rehabilitation and coming back out. But yeah, any questions for us while you've got us? Will?
Could you share this presentation?
Yes, absolutely. Yep.
Troy?
know what my question is. I'm just trying to frame it. Heard loud and clear. I'm not expanding earned time. I'm gonna want to get some more thoughts on what we might be able to do or what should we do as far as improving the notification system. I'm curious the degree to which the backlog is having an impact on this as well. I guess this is just a tangential question for me, but like I can come up with an example in my head. I don't know if it's realistic or not, where a person has been detained pre-sentencing. They get to the sentencing process and it's time served. Does that surprise people? Is that part of this? No, you're saying.
No. I think this is why they're.
No, I think because upfront,
Just identify.
sorry, if I could place again, just talking out loud. We're Shay and I, the state's attorney's office and the victim advocates there, we're staffed with people. So we're having those conversations with victims. We are having that negotiations. They're part of all of that. So they're informed throughout the process. They might be unhappy with the outcome.
Sure.
We're certainly letting them weigh in and then ultimately informing them of like how that's actually going to look and play out. And they have an opportunity at that point to offer a victim impact statement to the judge. So if we've done something that they're unhappy with, they at least have an outlet, right? Where they can speak directly to the court and say, I don't think this is enough. When we're moving things post adjudication.
Yep. Yeah.
But if they do that, which is
And this is
asking them like,
just-
hey, what you thought what they were gonna get or not.
This is like one more punch, meaning if like parole doesn't surprise them, but to know that earned time now is going to impact even the parole portion of their sentence it's feeling like salt in the wound. Well, that's probably euphemistic. It feels pretty shitty. Yeah.
Yeah, I'd say that in general, and there's a lot of pressure on our offices as well to resolve cases in the exact manner that you described in terms of getting someone who's been held for a couple of weeks, let's say with a hold without bail. Let's say they want to talk with the state's attorney from Rutland and say, I'm ready to plead to counts 1 and 2. I want to get out. That communication is happening contemporaneously with the victim advocate. Hey, there's a likelihood that today during the status conference or the bail review hearing or the weight of the evidence hearing that they're going to plead out. So we really pride ourselves on contemporaneous communication.
I'm going to call it Vance because that's what's on my screen.
By fault.
What's your advice here? Scrap it? Find something new?
Shay Kennedy again. Vine has a lot of potential to communicate in real time what is going on with a defender sentence. But the way it is currently set up and the manual labor required to actually input victims into this system does not exist. Okay. And so a rollout of this program is happening post-sentencing. And a lot of victims are then going to go back to their victim advocate that they worked with at the state's attorney's office when we're not necessarily involved anymore. It's not up to us. It's up to DOC and their calculations. When we're balancing caseloads of 500 plus criminal matters with thousands of victims and multiple cases resolving at the same time, making sure that we understand and hear a victim and make sure their input is heard at the time of sentencing, like having some finality, I think, is extremely important to the victim experience.
So do you have any recommendations on the Vine questions?
We do have some. And I think we're working through some of these with some of the DOC staff. But one of the things, it's a pipe dream, I'm just going to put it out there. We are currently working on a new case management system in our department. And one of the things that there's all these integrations with things like WatchGuard for body cam, Odyssey with the court system. Annie Noonan and I have been talking about this rollout for a while now. One of the things that we could potentially look into, and we don't know if we can do this, but where victims' information is already in our database, working on an integration with DLC system so that it could be seamlessly over there. Now, we'd want to make sure we provided notice, permission, like 3 ways from a Sunday, so that people know that their information is being transferred to another executive branch entity. But that's an area that I think we're interested in working on. I know it's come up in some group meetings. Another area is just, I think, it's a training piece, and it's for law enforcement, it's for everyone that's involved in the system, about the victim advocates and their limitations. When we get a call after sentencing, we don't know what's going on, and having other entities, whether it's the police, whether it's DOC, whether it's community supports, having the information so that they can support people after conviction. In my opinion, bluntly, people should be able to reach persons and people to have conversation about what's happening. And it's hard work, it's difficult work, and it requires adequate staffing. And this year we're asking for more victim advocates because the 600 per that we're dealing with is inappropriate according to studies that have to do with trauma and other things.
So that's the policy ask.
Well,
The Vine policy, we don't have to fix the Vine.
That I would, there are probably pieces to that I would defer to DOC to talk about how Vine is working. In terms of our experience with it, we can't be the solution to Vine not meeting its goals, if that makes sense. Thanks, James.
I want to go back to earned time real quick. So you mentioned this particular case from the 80s, and I'll admit I'm blanking on when earned time went into effect. It applies retroactively to any case that's currently in DOC. Now, I guess whether you could attest to it yourself or whether it's legally allowed, I'm not sure how to, phrase this, but when you're now going through cases that involve a crime like that, do you try to increase the minimum and maximum so that if earned time's fully utilized to the extent it's allowed, it kind of goes back to what it used to be in the 80s? Because that sentence in the 80s was made, to be with the system without any earned time. But now that you have that factored into it, I'm just curious if the courts and the state's attorney's office already do factor that in, because that's how I would see kind of a loophole around it.
I might like to actually ask that our state's attorney, this is what happens. If the state attorney from Rutland could answer that.
Oh, hi.
Sure, Ian Sullivan, Rutland County State's Attorney, for the record. The short answer is I don't think so.
Okay.
At least from my experience, being a prosecutor and being a law clerk in Vermont for the last well over a decade now. Sentencing trends have continued downward. That experience began before earned time, and I believe it has continued post implementation of earned time.
And obviously judges have the discretion to sentence. We make arguments, but the judges are the ones that impose the sentences just for baseline.
Yeah.
Sean?
I mean, doing post-conviction relief work from cases in the 80s and 90s, the sentences that were coming out of courts then were appreciably longer.
John?
Just looping back to the advocates are carrying caseloads of 500 to 600 people. Wow. What is an ideal number?
Yeah, so there was I'll send you all a study for you to have on your website. I think the number I'd want to get back to you more specifically, our target is we're shooting for something that's more in the 150 to 200 range. If you look at prosecutors, our prosecutors are carrying 300 to 400 cases. So we have 58 deputy state's attorneys and 27 victim advocates. So it makes sense that their caseloads are about double because they're covering the same number of cases. So we're looking to reduce that. This year, I'll say openly, we're looking for at least 6 victim advocates to help alleviate some of the pressure.
And that really is only a quarter of what you really need.
And sorry, I'm going to interrupt again. I I think one of the reasons that the in-person interaction is so important is because it is a way of returning agency to people who are harmed by criminal conduct.
Mhm.
It is a way for them to communicate with someone who is flesh and blood, cares about their experience in a way that, sure, technology is great. I like knowing when my UPS package is showing up,
Right.
but that's a different experience. That is a different experience than being stabbed, sexually assaulted, and having actual victim advocates who can explain, take the time so that folks can understand when somebody's being released, why they're being released. That, it might not make everything perfect, but it at least returns some agency to people who are harmed by criminal.
So we'd be supportive of DOC having whatever resources they need to make the system a bit more seamless, because I think we all deal with resource limitations.
Thank you for addressing that, because we had talked about this a little while ago. And the integration was one of we will have for DOC too, is how to integrate the two systems and make it more seamless. So, more suggestions is great on how to do that. And I don't know if DOC's got to have that ball or not, but that's the conversation we had prior was that's a pretty big, pretty important aspect of this, is to be able to have them more seamlessly integrated. And like, in my head, I just always think of weird things, but like if you get your bicycle stolen off the yard, kind of sucks. It's bad. But as sexual assault or, armed intruder in the middle of the night, those things are much more traumatizing. And that people that go through those kind of things are similar, deserve more than a text message. And it shouldn't be, I can't help you now, or I don't know what's going on because now it's in this other system. So.
Yeah, any other questions? We really appreciate the opportunity to bring in some folks from the field, because I drone on in the building all the time, and it's so much better when we don't do that.
Do we have an estimation of how much it would cost to upgrade the Vine system or to just
That's a deal.
overhaul it?
That's
Okay, that's gonna be.
Yeah, what we'll do is we'll investigate making sure that we're talking on the integration of any data we're collecting on victims, contact information, to see how we could potentially integrate. Right now, we're dealing with some very complex integration questions about integration with the courts, integration with law enforcement databases on the front end of things. So
Make sure you remember
it's a part of that conversation.
I'll risk.
Okay.
Hold it to.
Any other questions on this aspect?
Sir.
We're good. Thank you so much.
Thank you all so
Very
much.
much.
Thanks for- Thank you all for coming.
Thank you.
Thank you for what you're trying to do.
Thank you all.
And then,
Can go right in or break.
well, at least in my experience here, and I don't know if Phil's been in this committee, you guys, but in my committee where I came from, we never started early because the audience expects you to be at 1:00. But Phil, what have you guys done in the past? Do you just roll in if you're early, or?
Whatever the chair tells me to do.
I'm just trying to see what the answer. Let's take a 10-minute break and then we'll start early, but we'll get that out of the post lunch break.